First try. Joining us now to discuss, Andre Segura with the ACLU, also Dan Stein, president of the Federation for American Immigration Reform. It's nice to have you both here. This takes effect on Thursday. And let me begin with you, Andre, because we did not see the protests, thousands of people at the airports, etc. This is different. The question is, to what extent is it different? And that's an answer that will only come from the courts, from these challenges. But I would pose to you, there is no mention of religion in this one, for example. You guys still want to fight this.
Right, and in the first one, to be clear, there was only one mention of religion, but what we're arguing is beyond that. You have to look, and courts allow you to look beyond the four corners of a document to say there was discriminatory intent based on religion.
Intent. Just for our viewers, you're talking about, and correct me if I'm wrong, when the president said during the campaign that he will institute a Muslim ban. Legally, that's a hard argument to make, that intent before someone was in office is what is part and parcel.
It's not, because this is directly connected to what he wanted. He said, I'm going to have a complete and total shutdown on Muslim immigration. And this is what he's trying to do through proffered security rationales. But we know in the original order, that carries on to the second attempt, at which they waited to do and now have stripped it of certain things to try to pass legal muster. But it's very clear the president has not said anything genuine to change his original rationale. It's still pretty much the same thing.
So, Dan, what do you say to that? Because you could also point to Rudy Giuliani's comments, right? Someone who was very close to the president during the campaign and still is, who said, look, the president called me up and said, how do we make this Muslim ban legal? Does that hurt them with this second attempt in the court system?
Look, we think the Trump administration has done an excellent job in tightening up the original drafting, excluding permanent resident aliens and others to, in the four corners of the document, rely on a very heavy basis of statutory authority. We're talking years, decades of practice, ratified even by the Ninth Circuit. The president has this delegated authority from Congress. And by excluding permanent resident aliens and eliminating any reference to religion, I mean, this thing is buttoned up and airtight. And part of the reason they went back and redrafted the executive order was they wanted to make sure that an 8-person Supreme Court would uphold the constitutionality and legality of this ban. We are totally confident.
What about the fact that one of the senior advisors of the White House, Stephen Miller, came out on Fox News, just about a week or so before this second executive order was handed down and said, fundamentally, you're still going to have the exact same basic policy outcome for this country. He said these are, quote, minor technical differences. I mean, the first one did not hold up in the courts. What do you make of his statement saying this is essentially the same thing?
Eliminating lawful permanent residence from the ban is a huge change in the substance, as well as the procedural due process arguments constitutionally. But in the end, if the Hawaii representatives, if the state of Hawaii's arguments were to prevail up to the Supreme Court, it would turn the entire statutory basis of our entire immigration law on its head and suddenly hamstring Congress and the president from restricting immigration on an emergency basis for a whole range of reasons that have never been considered by a federal court before. This goes to the very essence of sovereignty, what a nation is. And both Congress and the president's authority are at their highest ebb in the drafting of this kind of resolution to keep us safe.
Look, we're tight on time. I appreciate you both being here. I'm sorry we don't have more time for you. We're going to keep talking about this, but Andre, final word to you. He's saying, look, Statute 1182 gives the president sweeping authority on issues of immigration, which it does indeed. The problem with the first one is you can't discriminate on, where someone's coming from or the religious minority part. That's out now, and you've got 6 instead of 7. Yes, they're Muslim majority countries. And how much harder is this court fight for you guys this time around? Green card holders aren't included. Legal residents aren't included.
Look, to be clear on Dan's point, he's wrong about the statutory authority. The president can designate certain individuals as having a potential terrorist threat, but what he's is designating all individuals from now 6 countries, Muslim majority countries, as effectively terrorist threats. And that's something that he can't do and has never been done, contrary to Mr. Stein's
for a brief amount of time, for the 3-month period. We are out of time. You'll be back. Thank you guys both very much.